Check. Okay, good day, guys. And we're back for the 2023 installment of the forecasts for the upcoming bar examinations. Oh, wala nang intro. Let's start. Please do see our disclaimer. Okay. Okay, this is for political law. Okay? Start. Question 1. Magaling Healthcare filed a complaint against PhilHealth alleging that the organization failed to pay or address the remaining 160 reimbursement claims within the required 60-day period as mandated by the rules. PhilHealth Board defended its refusal to address certain claims and the denial of 60 claims by citing PhilHealth Circular Numbers 17 and 19, which prohibits claims for services obtained during medical missions or delivered through recruitment schemes. The RTC ruled against Magaling Healthcare, claiming that they did not comply with the procedural rules in pursuing its claims. Is the RTC correct? Suggested answer. No, the RTC is not correct because Magaling Healthcare's complaint falls on the exception to the rule of exhaustion of administrative remedies. The Supreme Court, in a number of decisions, stated that the application for the rule of exhaustion of administrative remedies are not applicable when to require exhaustion of administrative remedies would be unreasonable and when there are circumstances indicating the urgency of judicial intervention. Both exceptions are present in Magaling Healthcare's complaint. This is based on the case of PhilHealth versus Urdaneta Sacred Heart Hospital. Second question. On September 5, 2002, Marisol filed a complaint affidavit before the Civil Service Commission alleging that during her marriage to Jason contracted a second marriage to Rosa, an employee of the Department of Foreign Affairs. On February 3, 1997, this prompted Mirasol to file a criminal case for bigamy before the Regional Trial Court of Lucena City. Both Rosa and Jason pleaded guilty during the arraignment, resulting in their conviction for the crime of bigamy. The Civil Service Commission (NCR), through a formal charge, indicted Rosa for the administrative offense of conviction of a crime involving moral turpitude. The Civil Service Commission (NCR) found Rosa guilty of the administrative offense and imposed the penalty of dismissal from service, along with the imposable accessory penalties. Rosa argues that suspension should have been determined as the proper penalty. Rule on the decision of the Civil Service Commission (NCR). Suggested answer. The ruling of the Civil Service Commission (NCR) is correct because Rosa was convicted of a crime involving moral turpitude. Under the rules of administrative law, an employee of the government may be dismissed from office upon first commission of a grave offense. Jurisprudence has established that bigamy is a crime involving moral turpitude, a grave offense under civil service rules, based on the case of Gonzalo Macatangay versus Civil Service Commission. Next question. Members of the PNP in San Fernando, Bukidnon established a mobile checkpoint to enforce the COMELEC gun ban. During a routine inspection at the checkpoint, Marcelino was flagged down by the police officers and asked to present the certificate of registration, and official receipt of his motorcycle. However, Marcelino failed to provide these documents. The police officers grew suspicious due to Marcelino's inability to produce the required documents. Consequently, they requested permission to search the tools compartment and driver's seat of Marcelino's vehicle. During the search, they discovered 5 bundles of marijuana wrapped in cellophane. Marcelino was subsequently taken into custody and transported to San Fernando Police Station. At the station, Marcelino underwent an interview conducted by the police officers, and the confiscated marijuana was marked as evidence. The substance was later examined at the PNP Crime Laboratory where it tested positive for marijuana. Marcelino denied allegations and further claimed that the warrantless arrest made by the Philippine National Police was illegal. Rule on the argument of Marcelino. Suggested answer. The argument of Marcelino is groundless because the warrantless arrest made in this case is grounded on a valid search. Existing jurisprudence tells us that checkpoint searches are considered valid as long as it is limited to a mere routine inspection. After failing to produce the documents to prove ownership of the vehicle, the police have probable cause to justify a reasonable belief on the part of the law enforcers that either the motorist is a law offender or that the contents of the vehicle are or have been instruments of some offense. Based on the case of Rolando Uy versus People of the Philippines. Next question. The municipality of Wanay, Iloilo implemented the Rescue and Emergency Disaster Program in collaboration with the Department of Health. The program aimed to purchase medicines, equipments, and devices for distribution to municipalities. Mayor Umaga entered into a memorandum of agreement with the Department of Health, and the execution and implementation of the program were facilitated through a Sangguniang Bayan Resolution number 313-2000 following the publication of the invitation to bid in a local newspaper. Pharma E, Drug M, Pharma Wealth responded. However, the bidding was postponed due to the absence of the provincial auditor. Despite the absence, the Committee on Awards proceeded with the bids and recommended the award to Pharma E and Drug M. Mayor Umaga approved the recommendation, and the medicines were immediately delivered and received by the mayor. Purchase orders and certificates of acceptance were issued, and the municipality issued checks for payment the following day. During the post-audit, the provincial auditor issued a notice of suspension and notice of disallowance. Mayor Umaga and Treasurer Roa were ordered to justify several matters, including the failure to notify the office of the provincial auditor of the bidding, the absence of a performance bond from the winning bidder, and the allowance of bidding by Pharma E and Drug M, despite both being owned by Rod Gun. It was discovered that both companies were owned by Rod Gun, and Pharma E had a suspended accreditation during the bidding. After a preliminary investigation, the Office of the Ombudsman Visayas found probable cause to indict the municipal officers involved in the bidding, including Rod Gun, for violation of Section 3E of Republic Act 3019. Is the Ombudsman correct in including Rod Gun, a private citizen, for violation of the Anti-Graft and Corrupt Practices Act? Suggested answer. Yes. The Ombudsman is correct in including Rod Gun for the violation of the Anti-Graft and Corrupt Practices Act because he acted in conspiracy to commit graft and corruption. The Supreme Court established that private persons, when acting in conspiracy with public officers, may be indicted and, if found guilty, held liable under Section 3 of Republic Act 3019, in consonance with the avowed policy of anti-graft law, to repress certain acts of public officers and private persons alike constituting graft or corrupt practices act. Here, Rod Gunn's actuations reveal his joint purpose, concerted action, and concurrence of sentiments with his co-accused public officials in charge of conducting a flawed bidding to justifiably favor his business entities, based on the case of Villanueva versus People of the Philippines. Next question. Gainesville has a construction project for the rehabilitation and improvement of its municipal waterworks system. Jitsukawa, the winning bidder, entered into a contract of agreement with Gainesville, represented by Kwan, for a total amount of 15 million pesos. However, after completing over 50% of the work and incurring expenses amounting to 8 million pesos, Jitsukawa was denied payment by Gainesville and Kwan, who questioned the validity of the contract. They claimed that Green, the former mayor of Gainesville and the current vice mayor, during the proceeding had no authority to enter into such contract. Jitsukawa, feeling that the refusal to pay was politically motivated, filed a complaint for the collection of a sum of money against Gainesville and Green before the Construction Industry Arbitration Commission, or CIAC. Green argued that he was authorized to enter into the contract based on Municipal Ordinance Number 2010-2, while Gainesville contended that the ordinance was in violation of the Local Government Code of 1991, and Green was acting in bad faith. Question: did Green have the authority to enter into a contract with Jitsukawa pursuant to municipal order? Explain fully. Suggested answer: yes, Green had authority to enter into a contract with Jitsukawa because the municipal ordinance in question was an appropriation ordinance, which authorizes or directs the payment of money or creating liability for the LGU. As a general rule, under the Local Government Code, no ordinance or resolution shall be passed by the Sanggunian without prior approval of a majority of all the members present. The exception is that for ordinances or resolutions authorizing or directing payment of money or creating liability, what is needed is the affirmative vote of a majority of all the Sanggunian members, whether present or not. Further, in the case of Kisumbing versus Garcia, the Supreme Court noted that if the project is provided for in sufficient detail in the appropriation ordinance, meaning the transactions, bonds, contracts, documents, and other obligations the mayor would enter into in behalf of the municipality are enumerated, then no separate authorization is necessary. Based on the case of Municipality of Corella versus Philconstruct Development Corporation. Next question. The problem at hand involves Starbs, who held the position of Division Chief of the DPWH. Starbs had the responsibility of supervising the recording and control of the Notice of Cash Allocations issued by DBM, or the Department of Budget Management, as well as the authority to sign requests for obligations and allotment ROAs and disbursement vouchers TVs for certain payment purposes. A complaint affidavit was filed against Starbs regarding questionable transactions related to the alleged emergency repair of a Nissan pickup of the office. Starbs approved the reimbursement and purchase of spare parts for the emergency repair of the vehicle, despite the fact that the spare parts listed in the requisition for supplies and equipment forms were not genuinely of an emergency nature. STARBS certified the validity of the expenditures and the completeness of the supporting documents. STARBS signed sections of vouchers intended for the department chief accountant and recommending approval, even though the funds used for the 4 vouchers were charged against the capital outlay fund, which is not meant for emergency repairs and spare part purchases. It was also discovered that STARBS signed ROAs for amounts exceeding 200,000 pesos and vouchers for emergency purposes and repairs without prior approval from higher authorities. STARBS, along with other employees, faced formal charges of dishonesty, grave misconduct, gross neglect of duty, conduct prejudicial to the interests of the service, and violation of several laws. STARBS claimed that he is accountable only for simple neglect of duty. Rule on the argument of STARBS. Suggested answer. No, STARB's argument is erroneous because what he committed is gross neglect of duty. As a general rule in administrative law, public office is a public trust, and public officers and employees must at all times be accountable to the people. The nature of STARB's position requires that he should be meticulous in the approval of disbursement of public funds and to be more circumspect in examining the documents for his approval. While the amount involved is not humongous compared to other government transactions, the fact still remains that taxpayers' money were spent at the expense of the government. Based on the case of Civil Service Commission versus Beray. Next question. The search warrant was issued based on the application filed by PO2OB1 and supported by an informant named Labrador, who provided 2 sketches of Padma's house in Gitna, Barangay Cuyab, San Pedro, Laguna. The search warrant authorized the San Pedro police to search Padma's house on the grounds of probable cause for possession and control of shabu. During the search, approximately 9 grams of shabu were found and seized from the premises, leading to the immediate arrest and detention of Padma for alleged violation of the Comprehensive Dangerous Drugs Act. Padma filed a motion to quash search warrant, arguing that it was in the nature of a general warrant and failed to provide a specific and particular description of the place to be searched. Padma claimed that the house number 972 did not correspond to her home address as stated in the warrant. Additionally, she argued that the warrant failed to distinguish her unit from the other units or rooms representing 4 other households inside the house located in Gitna, Barangay Cuyab, San Pedro, Laguna. Rule on the motion to quash. The motion to quash should be denied because the search warrant in question is not a general warrant. A case decided by the Supreme Court states that the test of whether the requirement of definiteness or particularity has been met is whether the description of the place to be searched under the warrant is sufficient and descriptive enough to prevent a search of other premises located within the surrounding area or community. A place may refer to a single building or structure or a house or residence, such as in the case of Bar, based on the case of Diaz versus People. After a police officer, again, this is a new question, okay. After a police officer 1 examination, the Civil Service Regional Office number 6 found discrepancies between the picture and the signature of one of its applicants, Dakat, in the application form and seat plan compared to those of his personal data sheet (PDS). Based on these inconsistencies, the Civil Service Commission concluded that the cat allowed someone else to impersonate him during the examination, with the impersonator providing the cat's personal information and signing his name. The cat denied the allegation and maintained that he personally took the police officer 1 exam on the specified date. The cat filed a motion to dismiss, arguing that the Civil Service Commission no longer had the authority or jurisdiction to conduct entrance promotional examination for members of the Philippine National Police. Is the cat correct? No, the cat is not correct in saying that the Civil Service Commission no longer had jurisdiction on the exams of members of the PNP because the Constitution grants the Civil Service Commission administration over the entire civil service. While it bears noting that on March 6, 1998, Republic Act No. 8551, which amended Republic Act No. 6975, became effective, transferring the power to administer and conduct entrance and promotional examination to police officers from the Civil Service Commission to the National Police Commission on the basis of the standards set by the latter, the lack of authority of the Civil Service Commission to conduct the examinations for Police Officer 1 on March 29, 1998 should not be used as a shield to the petitioner's wrongdoing, as he was not in good faith, as proportionately held by the Court of Appeals. To rule otherwise would be tantamount to condoning petitioner's dishonesty during the March 29, 1998 Police Officer 1 examination and allowing him to continue benefiting from the eligibility he acquired fraudulently. Based on the case of San Felix versus Civil Service Commission. Next question. Liwanag Electric, a public utility corporation operating under Philippine laws, holds a franchise to construct, operate, and maintain an electricity distribution system in the National Capital Region and other areas. On the other hand, the city of Muntinlupa was converted from a municipality to a highly urbanized city by virtue of Republic Act 7926. In 1994, the municipality of Muntinlupa enacted MO 93-35, known as the Revenue Code, which imposed a franchise tax on private individuals or corporations operating public utilities within its jurisdiction. The tax was set at 50% of 1% of the gross annual receipts from the previous year. Later, Republic Act 7926 was enacted, converting Muntinlupa into a city and adopting all existing Muntinlupa ordinances unless a new ordinance was enacted. Kay Moyan, the city treasurer of Muntinlupa, sent a demand letter to Liwanag Electric on June 28, 1999, requesting payment of the franchise tax from 1992 to 1999 based on the MO 93-35 and a circular from the Bureau of Local Government Finance. Liwanag Electric, however, contested the demand, arguing that the city of Muntinlupa, while still a municipality, did not have authority to impose and collect a franchise tax. Liwanag Electric ignored the demand letters and sought a declaration of nullity for Section 25 of MO number 9335. Will Liwanag Electric's petition prosper? Yes, Liwanag Electric's petition to nullify Section 25 of Municipal Ordinance 93-35 will prosper because it fails the formal and substantive test of a valid ordinance. The Supreme Court ruled that the formal test requires the determination of whether the ordinance was enacted within the corporate powers of the LGU, and whether the same was passed pursuant to the procedure laid down by law. Meanwhile, the substantive test primarily assesses the reasonableness and fairness of the ordinance and significantly its compliance with the Constitution and existing statutes. Applying the formal test, the passage of the subject ordinance was beyond the corporate powers of then Municipality of Muntinlupa. Hence, it's ultra vires. Based on the substantive test, Section 25 of MO 93-35 deviated from the express provision of Republic Act 7160 or the Local Government Code. Section 137 of the Local Government Code particularly provides that provinces may impose a franchise tax on businesses granted with a franchise to operate. Since provinces have been vested with the power, again, since provinces has been vested with the power to levy a franchise tax, it follows that municipalities, pursuant to Section 142 of the Local Government Code, could no longer levy it, based on the case of Meralco versus City of Muntinlupa. Next question. The Philippine Ports Authority, a government corporation with authority over the Manila International Port Terminal Complex, ceased the operations and equipment of Manila International Ports Terminal Incorporated, a private domestic corporation engaged in port-related services. MIPTI held a franchise granted by former President Ferdinand E. Marcos to construct and operate container terminals and other port facilities at the North Harbor. During the sequestration period by the Presidential Commission on Good Government, or PCGG, the MIPTI's operations were monitored without interference. However, President Corazon C. Aquino issued Executive Order No. 30 revoking MIPTI's franchise due to substantial violations of the Memorandum of Agreement and authorized PPA, the Philippine Ports Authority, to take over the cargo handling operation of the North Harbor. The PPA assumed control at MIPTI's operation, seized its properties, and appointed MetroStar to manage the port operations at North Harbor. MIPTI filed a civil action for damages against PPA, the general manager, and MetroStar, claiming violations of due process and the non-impairment of contract. MIPTI argued that its franchise, being a property right, should not have been revoked without prior notice and hearing. Additionally, MIPTI alleged that PPA's transfer of cargo handling operations to MetroStar and their use of the seized properties were unlawful. Rule on the validity of the executive order. Suggested answer. The executive order in question is unconstitutional because the Constitution expressly limits the power to repeal a franchise in that its exercise must be necessitated by common good or public interest. A franchise cannot be revoked or forfeited without due process of law. The 1935, 1973, 1987 Constitution commands that no person shall be deprived of life, liberty, or property without due process of law. This provision guarantees protection against any form of arbitrariness on the part of the government, whether committed by the legislature, executive, or judiciary. Here, having established that EO 30 is a legislative act, it is required to be published to satisfy the requirement of notice as part of procedural due process. However, standards of fair play and freedom from arbitrariness have not been observed in violation of MIPTI's constitutional right to due process. Based on the case of Manila International Ports Terminal Incorporated versus Philippine Ports Authority. Last question. On October 14, 2015, Mami Morada received a text message from her daughter that Junjun was arrested and detained by the barangay tanods of Barangay 176 Caloocan City for alleged theft of a mobile phone in the house of Barangay Tanod Randy. Mami Morada went to the barangay hall and she was informed that Junjun was already released on that same day from custody of the barangay as evidenced by the entry of the barangay blotter signed by Junjun himself. Rumors circulated within the barangay that Junjun has been extrajudicially killed and that his body was mixed in cement to conceal the incident. This prompted Mami Morada to institute a petition for the issuance of a writ of amparo to determine whether the respondents had violated or threatened to violate Junjun's right to life, liberty, and security, and to compel the respondents to determine the whereabouts of Junjun and the persons responsible for his disappearance or possible death. The RTC rendered judgment denying the petition. It held that there was no showing of any refusal on the part of the respondents to acknowledge or give information on Junjun's whereabouts, such that there was no intention to remove him from the protection of the law for a prolonged period. Is the RTC correct in denying the petition for the issuance of a writ of amparo? Yes, the RTC is correct in denying the petition for the issuance of a writ of amparo because not all of the elements of enforced disappearance are present. The elements constituting enforced disappearance as defined in Republic Act 9851 are as follows: that there has been an arrest, detention, abduction, or any form of deprivation of liberty. Second, that it be carried out by or with the authorization, support, or acquiescence of the state or a public organization, that it be followed by the state or political organization's refusal to acknowledge or give information on the fate or whereabouts of the person subject of the amparo petition, and that the intention of such refusal is to remove the subject person from the protection of the law for a prolonged period of time. For the issuance of the writ of amparo, it is not sufficient that a person's life is in danger. It is not even sufficient to allege and prove that a person has disappeared. Here, the third and fourth elements of enforced disappearance are absent. Based on the case of Fe Morada versus Randy Rias, and others.